we have about half an hour now for some discussion, but while people are gathering their thoughts together, I might just say a little bit of a summary from what I've been hearing. There's quite a broad canvas there, but some of the key themes really are about expertise, which John raised, and then Dave took up in talking about really the importance of finding a conceptual framework which distinguishes between some of the elements and concepts of cultural loss, which have already been used in law, and also that leading to perhaps to a different kind of relationship in terms of the research partnership between anthropologists and lawyers, because of the need to be more clear about what concepts are you using. Are you using connections? Are you using rights and interests? Are they interchangeable? Are they meaning the same sorts of things? And what's the role between anthropologists and lawyers in advancing that space? So that's just a quick canter across some key themes from my point of view, but perhaps people might like to ask questions now. Can we take the big screen down, Tegan, so we can see everybody?
Julie, I've got a question.
Go ahead.
I was intrigued by two elements. One is the idea of the compensation meaning to address future harms, the idea that the harm created has consequences for the future and the ongoing loss from the harm. And I want to then draw on David's comment that anthropologists should be engaged in the structuring and the governance arrangements for a PBC. And we are starting to see not so much prosecutions of PBCs, but proceedings brought to hold directors of PBCs accountable for how they've managed the assets of the PBC. And I'm just looking at that intersection of, you mentioned transparency and accountability and the need to comply with the rules for your, with the CATSI Act, and the need for the management of the compensation in the future to have the anthropologist play a role in designing the governance and applying it. And so I guess they're two-pronged. One is to David to see how would that work, but the second one is the consequences of mismanagement of the compensation when you deprive the claim group members of what is meant to compensate them far into the future. And I'm not sure whether John can comment on that.
Who'd like to go first?
David, you go first, David.
All right. Look, I mean, in a nutshell, Susan, firstly, I think any involvement of anthropologists must be what's commonly called co-design. That is, it has to be done in very detailed consultation with the people concerned. That's the first thing. The second thing is, look, this is a vast area, but the second thing is that there's both, it's my view that both lawyers and anthropologists have not been rigorous enough in distinguishing between what I think of as two of a number of different governance arenas. One, the governance of the corporation, the stuff that comes under the CATSI Act, right? Or whichever act it's incorporated under, but that's the one for PBC. The internal governance, it's called in that act for a good reason. And then there's the governance of what it does. In the case of a PBC, one critical thing is what it does is set out in those PBC regulations. And that's consistently not given attention. How is it to discharge its obligations to undertake consultations with the native title holders who are particularly impacted by our proposal, okay? And too often, the governance of that is brought inside the governance of the corporation, and that's a disaster. Not least of all, again, a really common mistake, the membership of the corporation of the PBC is not the same as the membership of the group. It never is, it never can be. So where an anthropologist would work is not in the legal matter, again, it has to be a deep collaboration involving lawyers, anthropologists, and the people whose PBC is going to be. And they may well have a different role. The lawyers tend to work according to a brief, whereas anthropologists, we don't. It's more open-ended, it's participatory, it's immersion, et cetera, et cetera. So that's the first thing. Then the next thing is, where we're talking about large sums of money, I think it behoves anthropologists to bring our understanding of, yes, the ethical frameworks, the intense commitment to kin, and the role of families, what are called families. Now, Peter Sutton's families of polity, and the way in which too often the design of trust and so forth has this undifferentiated set of beneficiaries, right? Whereas that's not how people themselves see it. It is intensely divided into families, of course, there's interrelationships. And my own experience is that you work with the families, you work, what are their goals? If we're talking about, development and using funds to, compensation funds to address disadvantage, then the locus of those kind of matters are absolutely part of family responsibilities. And in families, you have people who more or less trust one another, have a look out for each other. They're the units you need to start thinking through how to build a system in which it's not, as I say, an undifferentiated group of beneficiaries, but a structured set of families, which, after all, is what's being recognised very often in a native title claim.
So
that's what I'd say.
John, a response from you. I'm starting to get a trail of questions here.
Okay, I'll be very, very quick and very mischievous. David, I'd have to ask you what part of your course of study qualified you to, and I'm not being nasty about this, it's a genuine question, to make a point, qualified you, or indeed any lawyer for that matter, to properly decide who should be the composite members of the PBC. I would have thought, from what I've seen, that anthropologists can well tell us who are the decision makers within a community under traditional laws and customs, and how those decisions are made. From my own observation, I would say that in the last 20 to 30 years, that has evolved very significantly in a more refined way, but still exists. But composition of PBCs and management of money and assets is not something that I'm aware of is an expertise of either lawyers or anthropologists at present. That's not to say we shouldn't be trying to get there and make it as good as we can, but as an expert, is that something that any of us have the expertise to do yet? I agree with something should be done about it.
Yes. Well, there's a couple of answers in there too, John. One is these aren't matters which are done as part of a court hearing, which has a very and justifiably so, allows us to give opinion evidence. Is that right? This is not opinion evidence. This is active involvement in working with the group and making suggestions to be considered in terms of the structure of its corporate governance, one, and two, how they themselves feel that their funds should be managed and how decisions should be made about the distribution of those funds. That would be not the anthropologist giving advice to a court, but an anthropologist working in a team collaboratively with people, the group concerned. There's a publication through IATSIS authored by Jody Neal and Tony Bowman and myself, are exactly around these kind of questions. So I don't think it's like giving evidence in court. It's an entirely different thing. It's the post-determination phase, really, rather than providing expert evidence in litigation. So that's part of it. And then the second thing regarding expertise, I don't see it as beyond the capability of us anthropologists to, we should be advising not on financial matters, but on the kind of groupings that can make decisions, who can support one another. And overwhelmingly, well, very commonly it is family groups, right? We can bring to the attention of lawyers working, maybe title holders, to set up a PBC, the really important distinction between who can be a member of the members of the PBC and the group, because that's a foundational principle which constantly gets PBCs into problems once they start importing native title decisions into the workings of the PBC as a corporation, and ultimately perhaps even decisions of the board as a board. So it's we can alert, because we're not lawyers, but we do understand very much the difference between a class, a category of persons, the descendants of X, Y, and Z, for example, on the one hand, and the membership of a corporation, which, apart from the first set of founding members, is determined by decisions of the board. It's a list of members who've satisfied the board. So those, the difference between a class and a set of people defined by a process, are exactly the things I would suggest that anthropologists can legitimately advise on.
And I think there's, this is a foundation for people to certainly talk to each other by email and so forth afterwards. But I'd like to go now to Sarah, who's got a question which I presume is for John. Sarah, you're on mute at the moment. Sarah?
Sorry, I'm muting.
Yes.
Hi. It's a bit of a comment and a question. I was struck that your wrap-up of the arguments that the Northern Territory government about compensation was sort of along the lines of, you know, it's a cultural, spiritual matter, so you can't put a value on it and it can't be compensated. I've heard the same sorts of argument when it's come to Aboriginal site desecration and so on, both in the Northern Territory and in WA. And I am wondering if now we have a precedent of compensation payment for that cultural loss, that these sorts of things might be easier to argue in some respects around heritage issues. And if the aspect tying in a little with some of what David's saying is protection of sites and cultural places is often one of the rights and interests that is described in a native title claim. If not, and this is partly legal, if there's a capacity for compensation payment for site damage in the context of native title determinations, I guess. I hope that makes sense.
The Northern Territory argument in Timber Creek is set out in the High Court decision, just as a recognition of that argument having been put. That's been lost, so there's no doubt about the right to compensation. There may be cases where the anthropological advice is that the best way to illustrate the significance of the cultural commitment and the loss of cultural worth by some compensatable act is the destruction of an object. I think that really has to be case by case, and that's at the moment where I think we are, that we're still exploring that. So your point is a very good one. It might be very demonstrative, and the recent example of Rio, not that that's in the context of compensation case at the moment, and that has the added complications of having been authorised by state approval, state certificate. But had it not been authorised by state certificate, that would be a massive piece of evidence and the groundswell and the reaction and all of that evidence would demonstrate how seriously the cultural loss was experienced by that community. So the answer is yes, but it depends on every case, I think, how that's going to happen.
Yeah, thank you.
I could say more, but I think there's time for other questions.
Thank you. So, Kevin, I'm wondering if your question could come now, and then we can come back to the question David has, which you'll see in the chat room for everybody who hasn't looked there already. Just to give you a heads up, this is about staging the contributions from anthropologists, which may in fact also go back to the kind of diagram that Dave had. But Kevin, if you would like to weigh in now, then we'll come back to comments on David.
Thanks, Julie. Thanks, Julie. Thanks, John and David. It's interesting that both of your presentation raised the issue of the right to trade and the impairment of that right. And I just wonder whether that particular right, or the loss of it or the impairment of it, actually bridges the bifurcated approach to how you quantify loss. For instance, if you have non-exclusive rights, but you have the impairment or the loss of the right to trade, is that not factored into the uplift factor in the economic loss component? So if it's 50% and you could actually argue you had a loss of the right to trade, is there an argument to increase the percentage from 50 to 60% maybe? And I suppose in the cultural loss, is the loss of the right to trade, granted that that you'd have to prove it's post 1975, going to your point, David, does the loss of that right, does that then flow into cultural loss, and how would that be quantified? And I suppose the follow-on from that is you then might need to have a whole range of variation applications so that people who got their determinations prior to the Akaba case and the determination and so forth to actually introduce that. So that's a question for both of you. While I've got the floor, can I actually just comment about the interrelationship of expert and lawyer? David, I think when you're getting into the litigation space, I think you might be blurring the role of the expert and the advocate. And I think one way of getting around it is to better utilisation of the researcher within the rep body, which is actually translates the expert evidence to the claim strategy. So I think I like the way you're saying it, but I think it's we're going to confront some problems when it comes to litigation if we're then using the role of the expert to be a quasi advocate. So that might be a solution to the way you're pitching it. In relation to PBC design, I'm just taking up John's point here. I really think that we've got to question our expertise in how a group governs itself. And I think the recommendations by both Anthro and lawyer can only be part of the recommendations as to which forms the basis on free, prior, informed consent of the group as to how it's going to determine things. So as long as we actually know, yes, there's an important role to play, lawyers in the corporate governance side, Anthros in the community governance side, but they're only recommendations on which the group must exercise free, prior, informed consent on how it moves forward. So there's a lot in there, but happy to, be keen to hear your comments.
All right, John, would you like to go first and then Dave?
Yep. There was a comment I wanted to make, because I'm not, David, saying that lawyers have an expertise that anthropologists don't have about compositions of PBCs. But one of the things I wanted to make a comment about it towards the end was to say that, and you can see this in the High Court joint judgment at 214, there are a number of things which are conceded or common ground in the Timber Creek case. Cultural loss was not disputed as a fact. That an award was appropriate was not disputed as a fact. The in globo approach, that is taking every bit of acquisition and then treating it as one acquisition for the purpose of quantification, was not a fact. It was an agreed fact. And then they went on to say, and the apportionment or distribution of the award was treated as an intramural matter. that it would not be appropriate for the ward to reflect the number of native title holders and so on. So it was not an issue in the Timber Creek case, and probably couldn't have been, how the money was to be managed when and if it was awarded. But it is an important matter. And it was common ground there that it was an intramural matter. And we often say that when we're setting up PBCs, that fundamentally it's an intramural matter for you, how you manage your community. But when we're talking about such large amount of monies, and they do have this generational protection, as it were, that isn't necessarily an assumption that will always be made. And I think then it is important for people of anthropological skills to act as advisors or consultants, but we all have to be careful that we reflect the wishes of the community, which is not the wishes of the individuals within the community at that particular time. That's a challenge legally and anthropologically. Now, we've all seen cases, I can think of a number, where people have controlled a community, some Indigenous men mainly have controlled a community, and 10 years later you find out something where they've lost control of it and another group controls the community and doing it in an entirely different way. Some more historical and practical and present, but the history shows a lot of that happening, so that the decision-making processes within communities have not always been as purely honourable as they should be in every case, and have not always been as purely effective as they should be in some cases. I don't know the answer to any of this, but I think we do have to grapple with it. The other comment, if we're talking about mixing the right to trade, if the highest and best use involves the use of the land trading in a way which might have been done, then I don't think you would be doubling up if you included that in cultural loss. If it doesn't, then the right to trade is really but an aspect of the right to support yourself from the land, taking directly from the land and then using directly from the land or giving to other people in exchange for what you need. I would have thought that could qualify as cultural loss. So it would depend upon its particular circumstances. I think just an illustration, the Django case, the Yalara claim, which never got going, as we discussed last time, I think it would be said by those whose land was acquired after the Racial Discrimination Act, incidentally, that the highest and best use of the Yalara land, having regard to the proximity of Uluru, was precisely what has happened, building hotels, building airstrips, blah, blah, blah. And if that were the case, you would not likely be getting something else for the fact that you were trading small pieces of product from that land at the same time, because your highest and best use for that land would be a much greater value, and you wouldn't include that in cultural loss, I wouldn't think then. So it would depend on the case again.
Thank you. Dave?
I'll go to Kevin's comments. Kevin, I think I'm completely in agreement with you. I mean, I was trying to not be as verbose as I usually am. When I talked about co-design, I was meaning precisely that this is not a matter of the anthropologists and the lawyers deciding what a structure was, but it needed to be thoroughly worked through with the group concerned. Absolutely. There's a whole set of reasons for that: ethical, more than anything else, political, and also practical, because unless you work intensively with people and they have a commitment to whatever the outcome is and have skin in that game, then it will fail like all other impositions on Aboriginal people have failed. So yes, and I think your idea about involving in-house rep body anthropologists is a really good and creative way of having another element in the anthropological kind of involvement that is not of the expert. And I don't think I spoke to it, but in my slides I did talk about the possible implications for the role as the independent expert. If it's the anthropologist engaged to be the expert to then also be in this other work, I think could be problematic.
So look, we're close to 4 o'clock. There's quite a long comment from Adele in the chat room. And Adele, perhaps you'd like to just summarise the point that you're trying to make there. You're on
Right.
mute.
Yeah, sorry about that. This is really fresh because I've had to deal with something like this just in the last 24 hours. So, financial matters aren't supposed to be part of anthropological training, but it's very often part of our brief when we're working for rep bodies. And I just wonder, to what extent is something akin to a rule book established or required to be established in relation to compensation claims, successful compensation claims, simply to establish protocols, rules for the distribution of compensation, because the understanding of the intent at the time of the determination will change in that group through time. And yeah, I just think it's probably absolutely necessary to safeguard the intent at the time, but also have a degree of flexibility, because perhaps there is scope to accommodate shifts in matters such as secession and that sort of thing. Who gets compensation when a group secedes into an area where a group that had received compensation has no longer got people there, or they may have people who've had no continuity of connection to country, or very little of continuity connection to society, come back in as those who are closer have passed away, and start, put it bluntly, throwing their weight around in terms of distributions.
Thank you. Anybody would like to respond to that?
Look, I think that's an absolutely valid point. It's something which is likely to happen more and more, and we still see it. We have seen it quite a lot, where the old community seems to have lost interest, as it were, or died away, and then one vehement younger member of the community wants to come in and redevelop the knowledge, relearn the language, relearn the stories, and take a lot of control of what's happening because nobody else is. We have to be able to accommodate that, particularly with large amounts of money, but I don't think we have a good system for that at the moment. And probably the land councils are the bodies which most likely would take that initiative. But from what we've seen, the more initiative they take, the more likely they are to be provocative to somebody else. And unless it's a very well managed process, which I think would be an anthropological role rather than a legal role, because you're much more experienced at dealing with the communities, that's a very difficult thing to achieve.
Thank you, John. Dave?
I make a comment, Julie, in relation to the question of royalties and so forth, quickly. Yeah.
Yes.
I mean, each body of experience, and the Central Land Council is a very good case, who have a whole unit to do with working with groups in the distribution or the of financial benefits from activities on their land. They deal at quite a substantial level, and they include anthropologists, but other community development of all kinds. So that there is that body of knowledge. There's also an accumulating body of knowledge of what works and what doesn't work in the mining agreements across Australia, and what's been learnt from those and what's not, what clearly doesn't work. One of the problems is that the mistakes just keep getting repeated because there isn't attention paid to this interface between the trusts, sometimes with hundreds of millions of dollars, and the impoverished 300 or 400 people who are the beneficiaries. And there's a vast amount being placed into establishing a kind of a prudential trust run by, in one case I'm thinking by accountants and others in Perth, and people feeling completely dispossessed. The other extreme is one which has no prudential oversight of any kind, and which can often be quite disastrous. And right underlying all of this are really complicated political and ethical issues about how much is it anybody else's business to be involved in these matters? Isn't it up, if self-determination means anything, then it's up to people, and if they step up, they learn from it. Now, I don't subscribe to that to that extreme level, but these are underlying questions which go beyond relative expertise or otherwise of disciplines and go to the whole intersection of Australia, the Australian state with these groups, and the place of these sometimes very large resources, the role in social change for good or for bad. These are complicated arenas.
That's why I suggest that a rule book would be a useful thing to safeguard, to future-proof, so that land councils and people who are employed by them, or legal firms that are representing the people who are compensated, aren't acting in a colonial capacity, that the rule books are established by the recipients of compensation funds at the time of being compensated or at the time of the determination. And that rule book has protocols that accommodate it to be reviewed and revised according to social criteria that are set out by the compensated people themselves. Just an idea, but I just see otherwise it could be utterly horrendous in years to come.
So look, thank you, and we are starting to run over time, but I'd like to go back to David Trigger's question, which is regarding the staging of contributions from anthropologists. Would you like to problematize that first, David, and we'll have some comments, and that we'll have to close off after that.
Yeah, sure. Look, I'll be pretty brief. Dave and John and Kevin have all already pointed to the issue of what I think is the different roles from anthropology with this. Some reason I can no longer be seen, but that's, I'll just, as long as you can hear me.
Put yourself back on video.
You know, Julie, I'm trying to do that, but just listen to me rather than look at me. Look, I'll be pretty brief. I've got messages on the screen saying cannot start the video. Look, the point is, Dave, especially, we have to surely be very careful about envisaging these roles for anthropologists, and that's what others have said. So in a really practical way, anthropologists are going to be engaged to prepare compensation reports on the one hand, and that's going to involve investigating really complex issues where we won't be able to foreshadow the findings. Anthropologists, if they're trying to assess, especially in different parts of the continent that have undergone enormous parts of change, Martin Place in Sydney was the example John used. If the complexity of the anthropologist who investigates what's going to happen to subsequent generations of young people as to the functioning of traditional law and custom and so on. So that's all essential, that it's independent inquiry, I would have thought, on the part of the anthropologist. And it's going to be counterproductive, as Kevin was saying, to conflate a sort of a collective work between anthropologists and lawyers at that point, including, I would have thought, if I saw in your diagram that anthropologists and lawyers would work together on what the impacts on native title rights have been. Maybe I misread that, I'm not sure. But so the point is, I think that this issue of compensation may well involve different kinds of contribution from anthropologists at different stages, preparation of compensation reports that'll be robust in terms of potential litigation and negotiations as to the independence of the findings, and then subsequently, I guess, other kinds of roles for anthropologists down the track. So that was really the point I wanted to make.
Okay, thank you, David. Now, David Martin, before you answer, I think Marnez also has a question about the diagram. And look, let me just say, if there are people who have to move on to something else right now, given that we're 10 minutes over time, please do so. And thank you for your presence. Those people who want to stay on, please do so as well. We can go to past, and then I will have to cut it off. Marnez?
Thanks, Julie. Thanks, Justice Mansfield and David, for the presentations. Yes, my question is about the diagram, David, that you put on. And I was wondering if you could just elaborate more on what you showed in that slide. Specifically, my reading of it was that you put the kind of the departure point being the compensable acts being explained. And then I'm kind of finding it a bit problematic from the analytical, if not methodological point of view, to put that departure point there rather than the belief system or the worldview and the life world, if you would like, being the departure point in terms of identifying what are the compensable acts, recognizing them, and then translation using your own kind of language in terms of that translation space. So I was thinking if you could just elaborate more on that, please. Thank you.
So, 2 sets of questions.
Sorry, before you start, I've just asked Tegan if she would put the diagram up again. Is it this one or is it the contribution?
Further in the one which has the kind of move.
This one. Thank you.
Yeah. Okay. So what I was saying there is, firstly, to go perhaps to David's first. What struck me in the discussion, the decision on cultural loss, is that it referred both to the connections under law and custom, and it also referred to native title rights and interests. Now, I myself don't really understand that, and I've had the beginnings of some conversations with John about that informally. But when I was going through this, it just struck me that we were being asked that cultural loss included both of those things, and therefore it seemed to me that we anthropologists had to both look at impacts on, the emic view, people's connections under law and custom to country that were impacted by those acts, and also, however, on the native title rights and interests. And then if you follow the logic of the recognition space, then if that is a translation, as we look at the diagram, the rights and interests are a particular kind of translation from that system of connections into a bundle of rights and interests. And if that was the work of the lawyers, then my question was, it wasn't a question of whether the same anthropologist working on the connections also works there, but it seemed to me, if it's the lawyers' jobs to kind of do the translation to the native title rights and interests, then does this involve a kind of collaboration? That was my question. I did say, is that an issue, right? I wasn't saying we need to do it, but if this is the case, if my reading is correct, then is that an issue? And I think it probably is. But there's a more general matter which I don't think I really talked about, but the very complexity of, depending on the arena, right, but the very complexity of the compensable acts, this intersection of other jurisprudence, like the Racial Discrimination Act and so forth, the timing that imposes, all these things mean that is an immensely complicated, what's going to come out of that is likely to be, in many areas, an immensely complicated set of different kinds of facts, different kinds of information, and that's going to require a much more intense, is the word briefing, a much more intense advice from the lawyers, briefing by the lawyers of the anthropologists than is classically the case in a connection report. So it's not that they're moving David, this is going to your question. This is not that they're moving a kind of an unhappy blending of the expert and the advocate, the anthropologist and the lawyer, but there's necessarily going to be deep engagement between the two in order that the anthropologist can properly come to a view on what the impacts are. See what I mean? That's really what I was getting at. And as I say, the thing about native title was my query. The court seemed to slide between the two things in its discussion of cultural loss. What does that mean for lawyers and anthropologists there?
Marnez, are you happy? John, would you like to add anything?
I was going to say very early on after David had made his comments, which are very interesting and I think provoking, and David Trigger also, I might say, is very helpful. The role of lawyers and anthropologists are quite different ones. The anthropologists bring a professional expertise to the information relevant to the proceeding, assuming that there is a compensation claim. The lawyers are not anthropologists, so our skills, if I can diminish them this way, are really the process and knowing enough about the areas to be able to ask the right questions. So as David has said, what compensatable acts or compensable acts might be the subject of compensation? That's a legal question because they're external acts which affect a community, but they're the acts themselves. The second step, as the High Court said, is then to say, what are the native title holders' rights and interests which they have pursuant to their laws and customs which have been affected by those acts? Now that involves defining the rights and interests. That is essentially done by the oral evidence, the historical evidence, the documented evidence, and the anthropologist then interpreting all that. A lawyer's job in that, like we all think we are, is to sort of be a semi-expert, enough to ask prodding questions to say, have you thought of this? Are you doing this? What about this? What about that? What about that? The knowledge gleaned from just being involved in the proceedings for the long time. We're not ever going to be anthropologists to be able to comprehensively and accurately answer those questions. It's the anthropologists that are. And once we've got to those things, then as the High Court said, the next step, if we say these are the rights and interests that might have been affected, and we've developed that as fully as we can with an expert who ultimately, I also meant to say, is an expert for the court, not for the parties. You all know that. Once you've answered that definitively, the next question is, what are the effects of the compensable acts on those rights and interests to that community? And again, the source of that information, the identification of it, is largely going to come from anthropologists through their reading and their exposure to the community. And then it gets to be the oral evidence that the anthropologists suggest or the lawyers go out and talk to. But fundamentally, it's an anthropologically managed process prompted by lawyers whose job it is to make sure we get the best package of evidence we can. But we're not the anthropologists. And although, as David rightly says, there's a lawyer and anthropologist partnership in a sense in this process, at the end of the day, every anthropologist involved would know far more about it than the lawyers involved. I don't know if that's an answer to your question, David, but
yes,
we're not anthropologists.
David Trigger, you still alive on there?
Yes, I'm here. You just can't see me. I'm sorry about that.
Okay.
But I think that's really addressed. I think it's a conversation for further thought.
Yes.
But I do, well, it's stating the obvious, but I would like to make sure that the anthropologists who are approached to do work of this kind will be confident when they're negotiating their terms of reference and so on. Well, just to be clear that we cannot predict or foreshadow even the conclusion that there has been loss in absolute terms, let alone all of these complexities about the kinds of loss and the complex issues of change and so on. And I'm not suggesting that much of the anthropology won't find cultural loss, but it's just such a critical part of the learning that those of us who've worked in the area for some years, I think, have come up with. And the last thing I'd say is there is a bit of a risk. Some of our legal colleagues will try to gouge the anthropological reportage at times, not the experienced ones, but it's very much a sort of a two-way thing where the anthropologist has to be confident and robust in insisting on the independence of their work.
Yeah, I agree with that, David. That's a very important point.
And that seems a good point to end on, because it comes back to a theme that's been throughout this discussion, which is about expertise and the independence of the expertise. So thank you, John, for taking time, and for David, your presentation, and Tegan for helping to organise the smooth running of all this. So we're hoping that we can put this up as a recording once we've played around with it a little bit. And also going forward, you'll see on the screen now that Tegan has put together some questions for ongoing discussion, including the one I think that has just been talked about in the last few minutes, which is about the roles and contribution and at which point, etc. That's also captured there. Thanks, Tegan. So look, thank you very much, everyone. And to the managers who are on, we'll be talking tomorrow about this at noon. Thank you.
Thanks,
Thank
Julie.
you.
Take care.
Thank you.
Hi,
Bye.
Manaz. Bye.
Thank you. See you.
Bye.